if you're wondering what we're doing, we're just looking down the list of all the attendees, and both of us, Angela and I, are seeing lots of familiar names. It's nice to see everybody. Thank you for joining us. I think we'll get started slowly with a couple of introductions, and then hopefully by the time we really get going, everybody who wants to join will have joined. So welcome everybody. As I said a minute ago, this is our 42 Bedford Row webinar about how to enforce possession orders. My name is Iris Ferber and this is Angela Piears.
Hello everybody.
We are both experienced housing barristers at 42 Bedford Row, and we are very much looking forward to having a chat between ourselves about enforcement of possession orders, the various things that come up, the procedures, and all of the interesting points that, that you might want to hear about. Sadly, Zoom is not brilliant on interactive sessions. Otherwise, believe me, those of you who've had seminars with me before know that you'd be getting questions and you'd be required to participate very actively. But you've been saved from that by the way that Zoom operates. So let me tell you how this is going to go. We're going to have a chat, Angela and I, about various aspects of enforcing possession orders. We are going to, in the last section of the webinar, then open the floor to questions. And you will see on your screen, you'll be familiar with this from your other Zoom experiences, that there is a question and answer button on Zoom. If you want to ask any questions during the course of this webinar, please do type your question into the Q&A function on Zoom. And when we have got to the point where we are looking at question and answer issues, we will go to that box, we will look at those questions, and we'll have a chat and answer some of the questions that you have asked us. Only the easy ones. That's the plan.
No, only the hard ones.
Oh, right. Yeah. Well, okay, you can do the hard ones, I'll do the easy ones. Okay, so let's get started. Now then, I'm going to start with getting the right slide up here. Angela, what does enforcement of a possession order actually mean?
Well, this comes about when you have got an order for possession. You want to actually get the occupiers out. You want that eviction to take place. So you want the physical removal of those occupiers from the premises, and you want to secure your own possession of it so that you can do something else with it, like give it to somebody else or renovate it in whatever way. But certainly get those people out of the property, but you have to have that order first of all.
So I suppose it's the difference between having a piece of paper that says you're entitled to evict somebody and actually evicting them.
Yes, that's right.
That sounds quite important. Okay, well, perhaps there's another question then that follows on from that.
Yes, so I would say if you want to get those people out of the property, how do you do that? What are the powers of the people who go ahead and do that? They used to be called bailiffs in the county court. I'm not sure if that's still the right term.
I don't think that's the done thing anymore, Angela. That's the old-fashioned term. We don't use that anymore. We now call them enforcement officers, which is very corporate sounding and rather sad sort of phrase.
And is that the same in the High Court as well as in the county court?
Sort of. They get extra words in the High Court. They get called High Court enforcement officers, or HCEOs, as they like to call themselves. And they are a different group of people. But essentially, both groups, what we used to call sheriffs in the High Court, what we used to call bailiffs in the county court, they have the same powers. They do the same thing broadly, which is they are entitled, they have the right in law to actually physically remove the people that they find at the property in respect of which they are carrying out the enforcement. They can use force. They are the only people who can use force to remove people. And their job on enforcement is to fully vacate and then fully secure the property for the benefit of the landlord. So that's what you're aiming for. That's the bit at the end of this process where the enforcement officer actually goes in, and does the eviction.
Okay, so now we need to look at how you get there.
Well, I've heard, Angela, that it's much better to go to the High Court than to go to the County Court for enforcement of a possession order. Is that right?
I don't know. Well, I think that's what we're going to find out.
Okay, well, let's go to the next slide and see what that says. Okay, I think this slide tells me that we're going to start with going through how enforcement works in the County Court. And then we might look at the High Court, how it's different, and why you might choose the High Court instead.
Yes, I think we need to recap at the end the reasons why we might choose one or the other.
Yeah, okay, that sounds like a good idea. Okay, so in the County Court then, Angela, answer me this. What is the mechanism in the County Court for getting a warrant?
Well, first of all, you need that piece of paper from the court. You need that possession order. That is the critical starting point, really. Then you need to apply to the enforcement officer for an appointment.
Now, I think you don't apply to the enforcement officer. I think you apply to the court to put in a date, and then the enforcement officer attends on that date.
Yes.
So I think that's a court process rather than an application to the enforcement officer.
Yes, yes, of course, yes.
You were just testing me, weren't you?
Yes, that's completely correct. Yes.
Okay.
You apply to the court for that appointment date.
So is that what a warrant is? I mean, warrant is this word that we all use. Does that basically mean an appointment for a date and a time with the bailiff?
I suppose it is. It's a piece of paper. Let's call the warrant a piece of paper that the enforcement officer is holding. It's his permission from the court to go along to that property on a particular date at a particular time and go through the process that we've already discussed.
And when can you get a warrant? What sort of situation, what sort of court order allows me, the landlord's representative, to go off to court and ask for a warrant?
Okay, so let's go back to that really important piece of paper that you got in the first place, your court order. If that's an outright order and the court has said, yes, you can have permission in 14, 17 days, 28 days, or forthwith, you have to check that piece of paper, make sure that date has passed. That's the first critical point. Okay,
so you've got a possession order with a date on it, and the date has passed.
That's right, because that's the date when the people should have got out of the property and they haven't. And that's why you need to send the enforcement officer along.
So that's the sort of situation when you can have a warrant.
Yes.
When the date's passed. Is that the only situation then?
No, if you've got an order for possession, but it's been suspended on particular terms, for example, payment of rent, or compliance with tenancy conditions if it's antisocial behaviour, and you are saying, as the landlord, the condition upon which this order for possession the condition that it was suspended has been breached. So the payments haven't been made or the antisocial behaviour has continued. Then you can look to, can you enforce your possession order?
And I think, doesn't the difference between being able to get a warrant straight away and not depend on whether you've actually already been to court to prove the breach? Because if you've been to court, let's say you've got a suspended order, let's say for antisocial behaviour, on terms that the tenant doesn't commit any further acts of antisocial behaviour. Then there's an allegation that they have committed those acts. You make an application for determination of that breach. You get an order where the court says, yes, we make a finding that the tenant has breached the terms of the suspended possession order, and therefore the tenant must now give possession by the 1st of December. Then you've got yourself what's effectively now an outright possession order, because you've got the finding on the second application for the breach. In that situation, you can then go and get the warrant. Is that right? Because you've got a decision about whether or not the condition has been breached.
But if there is a suspension for payment of rent and the payment towards the arrears hasn't been made, do you need to go back to court for a determination, for a decision in those circumstances.
I remember there was a case about this a few years ago now, wasn't they? Birmingham and Flowers, something like that. Is that it? And that case was about whether there was a difference between going for a warrant based without telling the tenant you're going to do it, based on a non-payment of rent breach, versus going to court for a warrant without telling the tenant based on an antisocial behaviour breach, where there might be a lot more of an argument, almost a mini trial really, about whether or not there's actually been a breach. That's the difference, isn't it?
I think that's got to be the difference, because unless your accounting is particularly poor, and the tenant could challenge that they had been making payments and you simply hadn't been putting it in the right account, unless there's an argument along those lines, then a breach of payment conditions is quite clear. Yeah. Whereas antisocial behaviour is obviously much more difficult, far more nuanced, and obviously lots of arguments that a tenant could introduce that would require a definite decision before you could say, yes, I am entitled to enforce this.
Fine. Okay. So in that case, Angela, I think the next question is, what's the procedure? Because surely there must be a different procedure if it's a straightforward outright possession order that already has a date on it, or it's a suspended possession order and you're actually just alleging a breach of an antisocial behaviour term in that order. Those are the sort of two extremes, the most simple and the most complicated. So on the screen, everybody, you've got some slides, as you might have already noticed, and the one in front of you right now says CPR Rule 83.26, what is the procedure? And that's because, isn't it, Angela, the procedures for enforcement of all sorts of different types of orders, not just possession orders, are all in in Part 83. Part 83, Rule 13 is about the High Court in relation to possession, and Part 83, Rule 26 is about the County Court in relation to possession. And so you've got all your procedures, or most of the procedures, set out in this rule, Rule 83.26, right? So what is the procedure? I guess my first question to you, Angela, is do I need permission to ask the court for a warrant? Or do I just go ahead and say, please issue me a warrant? Does it matter what sort of possession order I have?
Yes.
When you're answering me that question?
Yes. Okay. There are some circumstances where you don't need permission, and there are some circumstances where you do need permission. So no permissions required if the date, as we've discussed already, the date on the possession order has already been set.
And passed. And expired. Right.
Or, as we've just discussed, the breach of a suspended order has been, an order of possession has been suspended on conditions of payment, and the payment conditions have been breached.
Okay, so what you're telling me is that if it's an SPO with no date on it, but the breach is non-payment of rent, then even though there's no date on the order, you don't need permission.
I think that's right.
Yeah, because it's a straightforward rent issue.
Yes.
So Parliament has decided, or rather the Rules Committee has decided, that tenants don't need protection from the issuing of a warrant without permission in a simple rent situation.
Yes.
Okay.
So what do you have to say at this point, which we will discuss at the end, I'm sure.
Yeah.
That, of course, the tenant can always make an application to suspend the warrant.
That's true.
So if there is an argument, then there is protection there, because the tenant will always have the opportunity to apply for relief.
I suppose the difference then is that in some circumstances, we'll come on to in a moment, where the Rules Committee or case law has considered that a tenant needs extra protection, there are extra steps added so that the landlord has to actually positively get permission, and that gives the tenant effectively an extra chance to oppose.
Yes.
And then, but in any case, even when there's no permission required, the tenant always has the option of taking positive steps to challenge the warrant.
Yes, I think that's just always important to stress that the tenant can always make that application, even though initially no permission's required.
So, okay, so if there's no permission required, what do I do? If I'm a landlord's representative, what do I need to do in order to apply for my warrant if I don't need permission?
Well, you need to fill in a form.
I love forms. I'm a great fan of forms.
Excellent. Well, that's a good job.
I'm in the right job, obviously. Yes. So what form do I need to fill in? Tell me.
It's form N325.
Oh, one of my favourite forms, N325. What about if I issued my possession claim on PCOL, on the possession claims online? Does PCOL allow me to apply for a warrant within the system without having to go on to an N325?
If you issued on PCOL, yes.
Oh, right, okay. So issued on PCOL, apply for a warrant on PCOL.
Yeah.
Didn't issue on PCOL, apply for a warrant using N325.
Yes.
If no permission is required.
Yes.
And that's if you've got an outright order with a date in it already.
Yeah.
Or it's a suspended order with no date, but it's just a rent arrears breach. Got it. Okay, so that leaves what's more tricky, which is the possession bit. Sorry, not possession, the permission. So when do you need permission? Okay,
exactly. So let's start off. As we've already discussed, if you've got a suspended possession order with no date on it, and there is a breach and it's not anything to do with rent, you need permission at that point.
Okay. Right.
But as we've already discussed, if you need a court to make a decision, has there, for example, been antisocial behaviour that has breached that suspended possession order?
Yeah. Understood. Okay, so that's where you need the court to make a decision about whether to give permission, because there's not been a decision by the court already about whether or not there's been a breach.
Is
there any other?
Clear.
It's not clear.
Yeah.
Is there any other kind of situation where you need permission?
So we've been saying, you don't need permission in these certain circumstances. Actually, you might do.
Oh, Angela, that's complicated.
I'm sorry. You might do if 6 years has passed since the possession order was made.
And that's is that for any possession order, even an outright possession order?
Yes.
Right, because it's been so long.
Yes.
Right.
Yes.
I suppose that makes sense, because the tenant might reasonably think that the danger has passed and it's not really fair to just suddenly spring an eviction on them 6 years after the order was made without a warning. Okay.
Yeah, they may be sitting there thinking, great, the landlord's just forgotten.
They might. Okay, so it's not that you can't have a warrant if a possession order is more than 6 years old. You just need to ask permission for it.
Yeah.
Okay. What is it? Any other situation?
Let's say you've got trespassers in the property.
Right.
You have got your order for possession, but it was made 3 months ago. So
when it's a trespass order, it's not 6 years, it's 3 months.
Yes.
Why is that, do you think?
I don't know, really. I think it's very important that you get the court to review the situation.
Maybe it's to encourage possession against trespassers to be carried out as quickly as possible.
Which makes sense, doesn't it? Because
will get more and more difficult after that time to work out who is and who isn't there, and whether the order applies to them and all the rest of it.
Yes, and they'll have become more settled in the property and establishing their own homes, their own daily routines, etc.
So you need to get on with it if it's a trespasser possession order.
No,
and you, again, after 3 months, you can get a warrant. You just have to ask permission.
Yes,
from the court. And sort of a bingo card extra here. There is one other situation where you need a permission, even if the order is less than 6 years old. Angela, again, what is that situation?
Even in those, so these are our exceptions to our initial easy rule.
Yes.
If the parties have changed, so let's say your tenant has died, the person who's now living in the property isn't the initial secure tenant,
or even if you have to serve the warrant presumably on the tenant's executors or person representatives, which is not the same person as the tenant.
Yeah,
that's also so. Let's say I get my possession order tomorrow, and the day after the tenant dies, even if I seek to enforce immediately the next day, I still have to seek permission, because at that point the tenant has died. And so actually I'm going to now need to enforce against the personal representatives, and therefore it's a different party. So even though I've taken action quickly after the making of the possession order, after the expiry of the date in the possession order, I still have to seek permission, because this is one of those circumstances that is unusual where the parties have changed.
Okay. Yes, it's a technical point. You don't want to be getting into lengthy legal hearings to sort that out. Apply for permission straight away.
After all, we keep talking about, in the last few minutes, permission, permission, permission. Actually, all that is, isn't it, Angela, is just a slightly different form. I love forms. This one is a form N325A rather than N325. So N325 is the form that you fill in if you're asking the court to issue a warrant for possession in the county court. N325A is the form you fill in if you're asking the court for permission and to issue the warrant once the court gives permission. Yes. So it's just actually, in reality, a slightly different form, and the court then considers what you've set out in the form, and hopefully straightforward, and it gives permission.
Yes, so you're asking for two things in one form instead of just
one. But it's nothing to be afraid of. If you do need permission, you just use that form, that other form.
I think that's the thing. Yeah, it sounds like a hurdle, but actually you will have got very clear reasons if you're applying to the court in any event. So it's just a procedure that needs to be gone through.
And I think it's right, isn't it? You don't need to give notice of that form being sent in. You don't need to give notice of that to the occupiers or to the tenant. It's not an application like an N244 application that requires notice. It is just a form that you fill in and send off to court.
Yes.
There's no requirement of notice when you either with or without permission. You just fill in the form and send it off. And okay, what if you get your warrant? So you either do or don't need permission. You either apply or you don't apply for permission. You apply either way for your warrant, and the court issues you a warrant. How long is it valid for, that warrant?
Well, I think that is a really important piece of information. It's valid for 12 months.
And is that it? After 12 months, you have to start again. You've got to ask for a new warrant.
No, you can renew it. You can renew it, but
but you have to ask the court.
Exactly,
and really, why would you take a year?
There is that question, but the trouble is that things do get very lengthy and bogged down, and
not in my cases, Angela, ever. No, my cases are always brilliantly well organised. But in other cases, when things are complicated and it might take time, and maybe various different dates for eviction have been put off,
I think real life does. Yes, it does intervene from time to time.
I guess you might be right.
I think it would probably be a good idea at all stages to bear in mind that it's always better to make an application before the expiry of anything.
If you think you're going to run out of time.
So I would emphasize that here as well. Yes, your warrant is valid for 12 months. That sounds like a long time. Make sure you're getting with it. Yes.
Yeah. Okay, next slide, please, as they used to say and don't say anymore. CPR Rule 83.8A, a great new coronavirus-based rule that is now permanent, as far as we know. We're not aware of the Rules Committee proposing to change it. The new rules since September 2020 relating to notices of eviction. Don't you just, you just get your warrant and then you go in. You don't have to tell the tenant anything about it, do you?
Oh, well, you'd be wrong there.
Oh, yes. Right, okay.
And I think you need to look at 83.8A in order to find that out.
Oh, right. Well,
just to make sure. So
what does it say then?
83.8A applies to writs of possession and warrants of possession. So it applies to the county court and the high court.
Right.
So
that's a spoiler alert.
Yes.
There, Angela. So there isn't a difference between the high court and county court in relation to these notices that you have to give to tenants. Is that what you're telling me?
Yes.
Okay.
That's right. This rule applies to both exactly the same.
Okay.
The notice of eviction has to be delivered to the premises not less than 14 days before the writ or warrant is going to be executed.
Okay, so it's minimum 14 days notice. And how do you serve it?
Well, I'm looking through 83.8A.
I've got some bullet points that tell me. Should I tell you?
Yes,
what you can look for, and you can tell us the bit of 83.8A. In the meantime, I shall tell you what the answer is. The answer is you serve the notice, as you said, Angela, at least 14 days before the date set for the eviction, by inserting a sealed but transparent envelope through the letterbox of the property. And if that's not possible, I guess because there isn't a letterbox, most likely, then you have to attach the sealed transparent envelope to the door. And if there is no door, which isn't going to apply very often in most of our cases, but if it's a trespasser eviction on land that doesn't have any buildings on it, then in the old-fashioned way that we all love, you attach some stakes, or you put some stakes on the land. I don't mean meat stakes, I mean bits of wood. And you attach to those bits of wood the same sealed transparent envelope, which shows the notice of eviction, the date and time of the eviction, that the eviction is due to take place. And you've got, don't you, to serve that notice on everybody, every type of possession order other than trespassers who never had a right to occupy. So if you've got a trespasser that used to be a tenant, you still have to serve the notice of eviction.
Yes.
If you've got somebody in occupation who is a tenant, still, obviously, you have to serve the notice of eviction. If you've got people in occupation who are there with the permission of the tenant, you've still got to serve a notice of eviction. The only situation you don't have to serve a notice of eviction is if it is a possession order against trespassers who never had any right to take up occupation of the property at all. And Angela, there's a lovely form, isn't there, for this, which I think is in the practice direction. So it's not just any old notice, it's a notice in a particular form, form N54.
Yes.
Is that right?
Yes. So this is the requirements there that you've been discussing are in 83.8A section 4, but at number 5 in this rule, there is one of those brilliant exceptions.
I love an exception.
So
I love an exception as much as I love forms.
You must serve this notice, but the court may dispense with the requirement to deliver the notice, or extend or shorten the time by which the notice of eviction must be delivered.
Now, I've come across this occasionally where there's a real urgency to get the eviction sorted, and when you apply to court for your possession order, you ask the court to include in the possession order a term that says that you're entitled to give short notice of eviction when you issue the warrant. Are we talking about that kind of thing? So basically the court can make an order changing that 14-day limit.
Yeah.
Okay, well that's good to know, because in a situation where it's really important not to give another 14 days after the expiry of the possession order, then you might want to ask the court to dispense with those 14 days. Now, tell me, Angela, what happens if the bailiff, enforcement officer, for whatever reason, doesn't manage to secure the eviction on the day? So they've given the 14 days.
Yes.
Landlord's given 14 days notice, bailiff's turned up, something's happened, police has turned up, in the end, they haven't managed to finalise and complete the eviction. Does that mean that the bailiffs can just turn up again a week later?
No. Well, the Rules Committee have covered this situation
I'm
as
relieved
well.
to hear that.
And so at 83.8A 2 B.
It's very memorable. 83.
Anyway, basically,
yes.
You just have to remember that further notice has to be delivered, but not less than 7 days before the writ or warrant is to be executed. So to begin with, it's 14 days.
Yeah.
If you don't get it done within that time,
Yes.
then you've got to do it. Then the next deadline is 7 days.
And you just do another Form N54, presumably,
Yes.
with the new date and time on it.
Yes.
At least 7 days into the future. Okay, well, I think that makes sense. So that's the new rules on the notice of eviction, and they are the same. That they're based on. They were originally enacted because of the lockdowns, but they've now been confirmed to be permanent. They're not going to be removed. So these are now the terms relating to the giving of notice for eviction.
And you know, again, it's so that everybody has got clarity.
Yeah.
There's no sort of mushiness of like, oh dear, you know, I didn't know about this. Well, yes, the right procedure was followed. This is what you have to do.
Wasn't there a
These
case
are the
about
days.
this recently? You were looking at it just the other day.
The case of Partridge and Gupta in 2017 did bring into play some of the grey areas, really, about when people could say, could argue that they hadn't had notice, or what was it that constituted notice.
So now we have a form.
Absolutely.
So as long as the landlord completes the form and sends it to the tenant or to the occupant, in fact, it is tenant and all other occupiers within that 14-day deadline. And then if unsuccessful within any further 7-day deadline, then they know they've complied with the rules. They're going to be entitled to execute that warrant. Okay, that's reassuring. Now, what happens, next slide, Angela, what happens if the landlord fails to follow the correct procedure? Because I can see that happening. It's not going to always go the right way.
No, well, then we've got this protection for the tenants that we were discussing earlier, that the tenant can apply for the warrant to be set aside.
But it's not automatic.
Oh, no.
The tenant has to actively make an application.
Yes. So quite often, obviously, you would get the application for the warrant to be set aside or suspended, and arguments for both could be advanced if the set aside wasn't successful in the first place. But what they can't do at this point is ask for the possession order to be set aside, because clearly that would be a completely different argument and procedure. So
we're just talking now about the enforcement procedure.
Yes.
Right, got it. Okay, so actually, if the landlord fails to follow the correct procedure and the tenant does nothing about it, carry on and have your eviction. It's only if the tenant raises the issue of a failure to follow procedure and asks for the warrant to be set aside that the court will look at it.
Yes.
Not that I'm saying that anybody should go ahead and fail to follow procedure.
That gives me pause, because applications can be made by tenants after an eviction has taken place.
Oh, right. I thought these things only applied before an eviction. Am I wrong?
No, I've definitely been in hearings after evictions, and tenants have argued that they should be able to go back into the property.
And this is one of those rare things where a court will listen to that argument, because this would be a breach of procedure on the application and service of the notices on the warrant.
Yes.
Okay, so actually landlords do need to get it right. Sounds like
it always
funnily
helps.
enough.
But yes, real life does intervene. That is the problem.
Okay, now the High Court. As I said before, Rule 83.13 gives us the rules about enforcement of possession orders in the High Court. And as you've said, Angela, there is a different and more fancy word for warrants in the High Court.
Yes.
Because the slide here says, what are the differences? Well, the first difference is it's not a warrant of possession in the High Court, is it? It's a writ of possession.
Yes.
But it's the same thing, isn't it? Basically.
Yeah, it's still the same thing. It's that piece of paper, permission, appointment. Yes, it's the same thing. It sounds more
fancy.
It does sound more fancy, doesn't it?
Old-fashioned.
Yes, that's right.
But it's basically the same thing. So can we stop there then? Are there no differences other than the name of the document, writ versus warrant, or are there some other differences?
No, well, what? So if you're a landlord and you've got your order for possession, there you are, you're going to either enforce it in the High Court or the County Court. it isn't as straightforward as that. If you want to go to the High Court, you have to make an application to transfer.
Well, that must be right, mustn't it? Because possession claims are always issued in the county court. If you issue a possession claim in the High Court, it just gets transferred to the county court. So you're always going to have your possession order when you get it in the county court. So if you want to enforce in the High Court, that must be right. There must have to be a transfer. So that adds an extra layer of admin, does it? Basically,
yes,
to the enforcement.
Yes.
Okay. So what do you have to do? What you just make an application to transfer the enforcement, or what?
Yes. Now there's a form, isn't there? There'll be a form that you have to fill in.
I think it's an N244, but I might be wrong. There might be a proper separate transfer form. I think the practice direction might have all the forms listed. Let me grab that bit of paper, Angela, and see if I can find it. I'm not sure. That's something for us to check, isn't it? I don't know whether there's a special form for transfer or whether it's just made as an N244 application, but it certainly has to be an application.
So you but
to
you
transfer the enforcement from the county court.
I was getting overexcited there. You have to apply to the county court for it to be transferred to the High Court. I'm not sure if we made that clear at the beginning.
Yeah.
So you haven't got out of the county court just because you want to go to the High Court. You have to ask the county court to release you effectively.
Yeah, and the county court judge makes that decision, right?
Yes.
And they have a discretion whether to do it or not.
They do. The applications made under Section 42 of the County Courts Act 1984.
Right.
That is the legislation, the legislative provision that allows you to do it.
And you can make the application during the claim time.
Yes.
You don't have to make it after the possession order was made. So if you already know that the court you're in has, spoiler alert, lengthy delays in issuing warrants, and you want to move things along a bit quicker, you can actually ask for the transfer for enforcement when you get your possession order. So you don't have then to go back to the same court, county court, and make a separate application for transfer. Yeah, you could do that.
Let's just put in one of those exceptions though.
Yeah. Okay.
So yes, you can do it during proceedings, or you can do it after the possession order has been made.
Yeah.
But the application must be made to the county court. But if the tenant has made some outstanding applications, say they're appealing about the possession order in the first place, you cannot go ahead, which makes sense anyway.
Yeah, you'll be turned down. Your transfer application will be unsuccessful.
Yeah, you can't,
because you're not entitled to a transfer while there are appeals or set aside applications outstanding.
Yeah, you need a definite decision before you move on to enforcement.
And is a tenant entitled to respond to a transfer application and say no, don't transfer it, or is it a one-sided process? No,
the tenant will be able to raise issues, and they may be keen to actually say, well, the reasons why the landlord is saying it should be transferred are wrong. And they're misguided. For example, let's say that one of the landlord's reasons is I want possession quickly because otherwise the amount of arrears is going to increase.
Right. And that's fair enough, isn't it? That's a good argument.
Yeah.
What's wrong with that argument?
Well, the tenant might say, well, actually, the county court isn't going to take any longer than it would do in the High Court. So there is absolutely no difference in the amount of arrears that are going to amass in the time between now and the date when you want me to leave this property. Okay,
so the tenant can have their argument with the landlord about whether the transfer should happen or not.
I think there will be other issues as well. The tenant could perhaps say, just give me a bit more time. I might be able to, sort things out. Whether or not that would actually find much sympathy with the county court judge would depend on the circumstances. There may be health issues.
Can I be cynical for a moment, Angela?
It's not like you.
No, I'm not a cynical person, but I just wonder whether a county court judge will look at the poor beleaguered admin staff and bailiffs of the county court, see an opportunity to get rid of a file that will otherwise need action taken in respect of it, and bounce it off to the High Court, where everybody sits around drinking tea and eating biscuits and waiting for the next case to come along, and think to themselves, I'll just transfer this case. It gets one file off my desk. Why not? Do you think that might happen? Maybe it's quite easy to achieve a transfer. I don't know. It's a bit cynical of me, but I think they rarely do refuse to transfer for enforcement. Maybe not for that reason. Maybe because tenants never bother objecting. Anyway, so that's a difference. You have to ask for a transfer. So that's an extra step.
In our questions.
Yeah.
Maybe if somebody has actually got experience, they could say whether or not a county court judge.
Be interesting to know if anybody can tell us
that the High Court enforcement officers sitting around drinking tea and eating biscuits.
I'm certain that somebody must have had that happen to them. We'll wait and see. We haven't looked at our Q&A yet. We will do that when we get to the end of our slides.
Have we completed the differences?
We haven't. We've talked about the transfer. That's a big difference, because obviously if you're in the county court, there's no need to transfer anywhere. So if you're going into the High Court, you've got an extra step of transferring. Then there are slightly different rules, which are actually pretty complicated. We've been banging our head against the wall trying to get this right for this webinar about what you do and don't need permission for issuing a writ in the High Court versus what you need permission for issuing a warrant in the county court. And we think the answer is the only situations in which you don't need permission from the court, from the High Court, to issue the writ of possession. In other words, the only situation where there's not the extra step of seeking permission to issue the writ is a claim against trespassers, a mortgage repossession, or an SPO that has been breached by non-payment of rent. Those are the only ones we think where you don't need permission of the court to issue the writ of possession. For every other type of writ, where it's not a trespass claim, not a mortgage repossession claim, and not an SPO breach by way of non-payment of rent, you do need, as well as applying for a writ, you need to apply for permission to issue the writ.
Yes.
And you need to give notice. Unlike in the county court, there's an extra step in the High Court, just I think historically, because the rules have been so different in the past. This is a bit of a hangover of those differences, that you do need to give notice to the tenant and occupiers if you're seeking permission to issue a writ, which you don't have to do when you're seeking permission for a warrant. You just fill in that N325A without notice in the county court. In the High Court, you do need to give notice. But that's it, I think. Other than that, once you've done the transfer, once you've done your permission, if you need it, once you've got your writ of possession, which is a different named document, it's a writ rather than a warrant. After that, your notice of eviction requirements under 83.8 capital A of the CPR is exactly the same. 14 days, transparent sealed envelope through the letterbox, or on the door, or on stakes, whatever is possible, ideally through the letterbox if possible. All of that within more than 14 days before the eviction, and it has to be notified in that way on a form N54, it's the same form whether it's High Court or County Court, form N54 in this transparent sealed envelope to the tenant and to all the occupiers.
Yes,
right?
and
So
it's
that's
all
exactly
set
the
out
same.
there. It is actually relatively clear in that rule.
Yeah, even though the rule has a horrible title, 83.8 capital A and all the bits, the actual details of rule 83.8 capital A are really clear. And the other thing I picked up that I thought was interesting, well, interesting for a housing lawyer, is that although you can apply, we talked about applying to stay a warrant, you can apply to stay a writ in just the same way as a tenant, that you can apply to stay a warrant. But if your application as a tenant is to set aside or vary the possession order that underlies the writ, rather than applying to stay or set aside the writ itself, you cannot do that in the High Court, because the possession claim hasn't been transferred to the High Court, only the enforcement has been transferred. So any application to vary or set aside the possession order has to be made to the original county court. That retains the jurisdiction in relation to the possession order. which I think is quite interesting.
Yes, it is interesting. It does make sense. It's a different thing. The tenant would be challenging a completely different thing.
Different document completely.
Yes, a different decision by the court. Yes.
So should we do a summary? I think we've got a
Yes.
nice slide on this. So here's a slide. The differences or the procedure in the High Court, which broadly speaking differs from the County Court, is number one, you have to make an application to transfer. Number two, in some cases, you have to seek permission to issue the writ of possession in circumstances where you wouldn't have needed to seek permission if it was a warrant in the County Court. You then apply to the High Court to issue the writ, something that is equivalent to what you have to do in the County Court. The writ then gives the date and time of the eviction, as the warrant would do, and you serve notice of the eviction on the occupiers, as you would do in the County Court. So that's, in summary, the process in the High Court. And the differences are the application to transfer and the requirement for permission in some cases, and the name of the document. It's a writ rather than a warrant.
And although there is this sort of extra procedure to do this, to get to the High Court, because the enforcement officers
are sitting around
drinking tea, it's probably it could be worth it.
Well, it'll be interesting again in the Q&A to know if people do find that even with the extra steps of transfer and permission, and notification of permission, that it's still quicker to get an appointment for a bailiff or High Court enforcement officer by transferring to the High Court than by staying in, say, Central London County Court.
Yeah.
Be interesting to know what people think about that.
Yeah, from practical experience, that would be good.
So we've done that. Why choose the High Court for enforcement? It's really speed.
Yeah,
it just tends to be quicker. And if speed is important, then that's why people do it.
Yeah.
Okay. We're really nearly run out of time, Angela. We've had so much fun. The time has just passed.
It's always fun talking to you, Iris.
Thanks, Angela. and you. We haven't seen each other for a very long time. Maybe we should do more webinars together. Then we'll actually talk.
I like this. Although everyone else isn't here in the room, so we can't see you. It's actually good to be in a room with somebody else rather than
across a screen. Absolutely. It's very nice. Okay, we are now on to questions. I'm going to open up our Q&A and see what lovely surprises we have there. Fabian, hello. Very nice to see your name. Haven't seen you for ages, Fabian. I hope you're well. Fabian has a question, which I'm bravely going to read out, even though I've no idea what he's about to ask, and I might not know the answer.
Okay.
Let's see what Fabian has to say. Question. We have a possession order against a tenant. We believe this person is now not in occupation, but other people are. Can we apply for a warrant, even if we believe this tenant on the order has left? Or does the possession order bind anyone in occupation? Or do we need a new possession order for the persons unknown? I know the answer to this, Angela. Would you like me to tell you?
I'm excited, yes.
The answer is that a possession order, get ready for some Latin, is an order in rem. Do you know what that means?
It means it's a real thing.
It's a thing.
Yeah.
Rather than in personam, which is against a person. And a possession order is an order for whoever is on the land on the day of the execution of the warrant of eviction to be removed. And that's why when you have to serve notices of eviction, you don't only serve them on the tenant, you always have to, Fabian, you always have to serve the notice of eviction on the tenant. Even if they're not there, you've got to serve the notice with their name on it at the premises. You also serve the notice on any occupier, because the order for possession takes effect when executed against whoever happens to be on the land at the time. So the answer is, it's fine. It doesn't matter if the tenant is there or not.
I was going to say,
the execution
as long as the possession order is against the tenant, because that is the person with whom you have the agreement, the contract.
Oh, absolutely. If you didn't have that, then and the tenant was on the land, you wouldn't have the right to evict them. But you get that sorted out at the possession order stage.
If you had an order that was against somebody else who had been in the property, but then the tenant came back, then, well, where are you going to be? The contract is still
but in that situation, you'd have been badly advised not to have sought your possession order against the tenant in the first place. So really, that's a situation that goes right back to the initial issuing of the claim for possession.
So whatever you do in the first stages, whoever else is in the property always get the order against the tenant, and then the situation that you're talking
assuming
about,
that's
Fabian, will be as Iris has explained.
Okay, now Paul, hello Paul, it's very nice to see your name here as well. You've asked a couple of questions about the process. I think we probably answered them during the course of the session, but let's just quickly cover them. So Paul, your first question was, what are the constraints in getting a transfer from the county court to the High Court to enforce a county court possession order? And the answer to that is you have to apply for the transfer. And the county court judge has a discretion whether to make the transfer. And you generally need to explain that you want to get on and enforce quickly, and that the High Court has a quicker enforcement process, and you explain why that's important. And most of the time, when you've got a possession order, the reasons for wanting it enforced quickly are going to be really easy to set out. It'll either be that there are rent arrears, or it'll be that there's ongoing problems with antisocial behaviour, or whatever the other issues may be. And then you ask about how the applicable rule, Paul, you ask how the applicable rules apply to unauthorised occupiers and trespassers. Well, as you've heard us describe, there are various things that you don't have to do in relation to trespassers. You don't have to give them notice of request for permission, that sort of thing. One thing that actually is slightly more onerous in relation to trespassers is that you do have to seek permission to enforce your order after 3 months, not after 6 years. So in that sense, getting an order against trespassers imposes an extra burden on the landlord. You've got, or it's not a landlord, I suppose, in the case of a trespasser, the owner of the land. When you've got trespassers, you've got to get on and enforce within 3 months, or you've got to take an extra step of applying for permission. Whereas normally with non-trespasser possession orders, you've got 6 years to enforce without the need to ask for permission. Okay.
Fabian,
let's see. Fabian
another question.
Yes, let's see, Fabian. Let's just have a read of this. Again, if it's something that we've already covered, we may skip over it, but let's have a look. You say, question following on from what was just said. This was at 5:22. I'm sure we said something very interesting at 5:22. What happens if an NTQ was served on the tenant for non-occupation? Then on expiry, the tenant dies. That's very specific. Do we still have to serve on the personal representative, or do we have to serve a new NTQ addressed to the personal representative, or just address the claim form to the PR? Fabian, I'm going to tell you off a little bit, because you are sort of hijacking our enforcement session to discuss steps that you'd have to take before issuing a claim for possession. So I will answer that question, Fabian, or Angela might, because I'm not so brave, but let's do it in writing in an email afterwards. Yes, because actually that's a difficult, that's a completely different question about service of notices to quit on a tenant who has died before we get to the point of enforcement. So Fabian, I will come back to you on that separately. Paul again. Paul has been busy. 5:30, Paul sent this. Can you please clarify the applicability of CPR, my favourite rule, CPR 83.8A brackets 6, Angela is now going to tell me what that says, in the context of lodgers and unauthorised occupiers remaining in occupation for a prolonged period of time.
So this rule
6 say?
Does not apply to writs and warrants of possession to enforce possession orders against trespassers, other than possession orders against persons who entered or remained on the premises with the consent of a person who, at the time the consent was given, had an immediate right to possession of the premises.
Okay, so what that is saying is you do not need to give notice of eviction to a trespasser. And that we did cover this actually, we just didn't use these very technical, rather difficult words. But you do not need to give a notice of eviction to a trespasser so long as they entered the land without permission. But if a trespasser is a trespasser because they started off as a lodger, i.e. with consent of the tenant, but they no longer have that consent, then you still need to serve them with a notice of eviction. So the answer to your question, Paul, is CPR 83.8A, notice of eviction, still applies to trespassers if they started off occupying with permission. But if they started off occupying without permission, if they were trespassers right from the beginning, squatters, they broke into the building and squatted it without ever having any permission to be there from anybody, tenant or landlord or anyone else, then the notice of eviction rules in 83.8 capital A do not apply. What do you think, Angela? Does that sound right?
Yes, sir. I think so. And it's interesting, isn't it? There's so many different circumstances to consider. So we always start off with a good rule, and then there are all these other points. Yeah. But I think that is relatively clear. If it's not, Paul, we can always address it in a further when we complete the notes, if anybody requires notes after the talk. Now we've got quite a lot of other questions, haven't we?
We do. What's the time? Let's just check our timings. Oh, we've got 4 minutes left. Right, there's a couple of people who've pointed out something which is probably schoolboy error by you and me, on the basis that we advise on these things in theory but never see them very much in practice because they tend to just happen, which is that the N54 form, the notice of eviction, is sent out by the court, not by the landlord. So I think we stand corrected on that. Because both somebody with a wonderful name, Anonymous Attendee, it's a good name. So Anonymous Attendee and also Fabian, thank you Fabian, have both said that the N54 normally gets filled in and sent out by the court and copied to the landlord. So that's a correction there. Thank you very much, everybody. That the N54 form is not something that you have to complete. It does have to be sent out, and you've got to, I think you do need to make sure that you've ticked off that it is sent out by the court, because if as landlord you don't check that and the notice hasn't been sent out in time, then you may be dealing with an unlawful eviction by the bailiff, which could then be overturned on an application by the tenant. So you want to make sure that the court does the proper thing and serves the N54 on time, but it's not your responsibility to do that, it's the court's responsibility. Peter, this is very helpful. Thank you, Peter, for this. We asked the question what people's experience was of transfer, and Peter says that regarding High Court transfer, Romford is very reluctant to transfer to the High Court, right, especially for secure tenants. So that's worth knowing. I mean, it may be that Romford are pretty good at getting their bailiffs, enforcement officers, in and evicting, and they don't have any particular delay or any particular pressure on the workload of their enforcement officers. And in that case, I can quite see why the court wouldn't want to be transferring. I think in Central London County Court, they're quite often desperate to transfer, as I say, because they've just got
this is
too much to do.
A moment where I just wish everyone was here in the room and we could actually have an interactive question and answer, because I would like to know what the reasons were that Romford have refused to transfer cases or express their reluctance, because it's helpful to know, so that you can maybe garner your evidence for the next application.
Interesting next question. I'm just sorry, I had a bit of a pause there because I was reading this, and it's a good and interesting question. I think the answer is no, isn't it?
I can't see that that's right.
Anonymous attendee, I don't know whether it's the same anonymous attendee or another. But hello, anonymous attendee. Thank you for your question, which is a really interesting one. Can you apply for a warrant and an application for a writ at the same time? What do you think, Angela? I don't see how.
Well, no, because the case is either with the county court or with the High Court. So you have to transfer from the county court to the High Court. So you couldn't possibly make both applications at the same time.
You're in one or the other, aren't you? You're either in the county court jurisdiction because you haven't transferred, or you're in the High Court jurisdiction because you have transferred the enforcement. So no, a really good question. I think the answer is definitely no. You have to choose which forum you're going into. Breathing space moratorium, our favourite thing, Angela. Peter asks, can the debt respite scheme, the breathing space moratorium, be used to suspend a warrant at any time? Well, the answer is that if there is a breathing space moratorium, you are, as a landlord, unable to apply for a warrant at all. So there's no possibility of enforcement during the course of the moratorium. Although I don't think there's yet any law on this, my guess is that if there's already a warrant in effect, which hasn't yet been executed, that will be stayed automatically by the moratorium, because one of the effects of the moratorium is to stay all enforcement proceedings.
Yes, so whilst the courts have a procedure that enables a landlord to take back the property, there are these checks and balances to protect the tenant, and that the moratorium is one of those, isn't it? It's to give them a chance. So
I think that's the answer, is you can't issue a warrant at all or apply for a warrant even if there's a moratorium. If one begins during the existence of a warrant before it's been enforced, I think it would be automatically stayed. That's my guess.
Now, I was just laughing at Charlie Kenny's
comment. Charlie, that's not fair.
In response to my point saying I'd like to know more about that. So Charlie Kenny says that he's reliably told by a DJ at Bromley that they're reluctant to transfer because their own enforcement officers are capable of executing their warrants, and B, that by transferring en masse, they would effectively put them out of a job. And I just think that's tremendous.
It is. That's the DJs looking out for the interests of the enforcement officers. Yeah. That's rather lovely. So there we are. So Bromley as well. Bromley and Romford both don't like transferring. In my experience, Central London are very happy to transfer. So really, it may well be to do just with pressure of cases on the court staff. That may well be what powers this in the real world.
And the value of transfer to the High Court is to get things done quickly. So actually, if you've got a court where your enforcement officers are acting efficiently, then there isn't a need.
No, and the transfer, that's right. The process of moving it to the High Court does take time. So if you don't need to do that, don't do that.
No,
absolutely. There's a couple of really interesting things here, Angela, really interesting. Diane, hello, Diane. Haven't seen you for ages. Lots of people on here that I haven't seen for ages. It's very nice to hear from you, Diane. You say that you've dealt with High Court sheriffs and they often will send over the N244 precedent, the request for requesting the transfer of enforcement. And I just wonder whether there's a sort of healthy competition between the county court enforcement officers and the High Court enforcement officers, where the High Court enforcement officers want to make it as easy as possible for parties to transfer enforcement so that, as the DJ at Bromley says, all the work goes to the High Court enforcement officers. That's a very interesting point, Diane, and it's interesting to know that they are happy to facilitate that process, the High Court enforcement officers.
I wonder, though, how the High Court itself views an N244 completed by an enforcement officer.
Well, I think all they're doing is saying, here's a form we use, fill it in. That's what they must. They're just giving you a template. Well, really they are, because probably everyone always says the same thing when they transfer. But as long as Diane puts her name at the bottom of it, changes the name of the tenant or the name of the defendant to be correct, and puts the correct address.
That is important, that the officers themselves can't step in and hijack the whole procedure.
No, because there has been some criticism, hasn't there, in past years, of High Court enforcement officers doing all sorts of shenanigans
exactly what
bypass the normal rules for enforcement. That's right. And then a really, really interesting final question, because I know we're just 4 minutes past the hour. But Sylvia, hello, Sylvia. Lovely to see. Well, I was going to say lovely to see you, but I can't see you. But lovely to hear from you, Sylvia. Sylvia asked a really good, interesting question. Final one, I think. Is it still worthwhile executing your warrant if you now know that by the date of the eviction, the property is definitely vacant? I would say it is worth still formally executing rather than just going along with a housing officer and just changing the locks. Why do I say that? Because until lawful execution of the warrant happens, the tenant hasn't yet been evicted. What if the tenant has left the property temporarily with an intention to return. Now you're going to say to me, Sylvia, yeah, but the furniture is all gone. They put a notice on the door saying, I have left, please don't contact me again. Well, you will all remember, I'm sure, etched into your memory, the case about unlawful eviction, where the tenant had taken all their furniture. This was not a case about enforcement of a warrant, particularly. This was a case about a tenant who had, in different circumstances, not involving a warrant, left their property. Do you remember this case, Angela? Taken all their stuff out, flat was completely empty, and there was a notice on the door, outside of the door, from the tenant saying, I have left and I am not coming back. And the landlord went in, changed the locks, and it turned out later that the reason the tenant had done that is because they'd been threatened by the next door neighbour, and they wanted the next door neighbour to think that they had left. But they hadn't actually left. It was not their intention to leave.
It sounds like a landlord's nightmare.
It's a landlord's nightmare. So you just never know whether what looks like a vacant property is really a vacant property. And if you've already got your warrant, you've already done all of that work, you've got a bailiff enforcement officer appointed for the date and time, I suggest you go ahead and comply with all of those procedures, just in case. That's what I would say. I think that's the counsel of caution that I would give.
I think so. And you would just never know when a tenant was going to make those sorts of arguments.
You would feel really silly if you just cancelled the bailiff and took possession one day early, and then it all blew up in your face, when actually if you just let the bailiff do their job the next day, it would all have been lawful. So I would just stick with the programme, stick with the procedure, even if you think that the tenant is vacated. Thank you for that, Sylvia, and thank you everybody for really interesting and nice, engaged questions. Although we both of us always feel sad on Zoom that we don't have more interaction with the audience, I think it's worked really well today, doing the question and answer.
Yeah. And it's great to see, it's great to see familiar names on those question and answers.
It's lovely. And
I've seen so many people having joined as well. So.
Yeah, it's great. And let me just flag up, everybody, the fact that we're going to do an in-person workshop at Christmas time here in Chambers. So if you, like us, are keen to meet up with people you probably haven't seen for a year and a half, please do look out for that email and join us in Chambers nearer to Christmas, sort of mid-December-ish, for a Christmas-themed housing workshop. Look forward to seeing you. Thank you, everybody, again, very, very much for attending, and see you on the next webinar. Bye now.